My lord, being compelled by circumstances, my lord, I am mentioning, my lord, for upgradation because the matter was on the earlier 2nd May of 2025. Matter was called on, but respondents did not respond. And since the private respondent blocked the PWD land in front of the petitioner's land, and also inspection was held, but thereafter totally blocked and made encroachment of the. So, my lord, on any date, my lord, as your lord.
Motion.
Motion, my lord.
September 4.
Grateful, my lord.
September 4.
288.
Under the heading fixed motion.
288.
My lord,
Give notice.
Yes,
you are
my
permitted to mention, my lord.
Yes.
Extension for interim order, my lord.
When it is expiring.
Last day of August, my lord.
Nini. Please give it. Tomorrow under the heading extension of interim order. Give a notice.
Yes.
Yes, call the list.
I am appearing on behalf of the petitioner in this matter. There is a typographical mistake in order. In order dated 4th August 2025,
Yes.
my lord directed the Block Land and Land Reforms Officer to demarcate. Block Land and Land Reforms Officer is the respondent number 6, but in paragraph number 10, 12 and 13, the respondent number has been typed as 5 instead of 6.
Paragraph number?
10, 12 and 13.
Give me a second.
Paragraph number 6 and 7 may be looked into. My lord will find my lord directed the BLRO, Block Land and Land Reforms Officers.
Take down. The instant matter is listed today under the heading to be mentioned. Since some typographical error occurred in paragraph number 10, 12 and 13, wherein respondent number 6 has been wrongly typed as respondent number 5. Stop. In view of such, in order date বলেছি এটা বলে দাও এই লাইনটা বলে একটু in the order dated 4/8/2025 have been has been no. Stop. In view of such, in paragraph number 10, 12 and 13 of the order dated 4/8/2025, wherever the figure 5 after the words respond number 5 appears, the same is oblique are deleted, and in its place the figure 6 is oblique are inserted. Full stop para. Necessary correction in this regard is made by me in court today. Full stop para. Let this order be treated as part of the order dated 4/8/2025 as passed in connection with the instant petition. 10, 12 and 13.
Yes, my lord. 10, 12 and 13.
Sir, don't, please wait.
But one prayer I am making, my lord, let it be re-uploaded in the site.
This order will be the part of the order. একবার check করো। Yes. This order will be the হয়নি complete হয়নি complete হয়নি।
Great.
Item number 2, there are two applications my lord, which perhaps my lord can be my lord. There's one can 4 and can
Give
10.
me a second, sir. হ্যাঁ
10
Can 4 আছে, can 4 টা আছে তো?
দেখছি না আচ্ছা ওকে
It is another heading extension of interim order.
Yes, my lord. That is my
Can
lord.
4 is the application for
So,
extension.
my lord, can 10 is the application for extension.
সেটা আছে বার করুন
But my lord, can 4 my lord can also have a look, my lord. Perhaps my lord, we can also,
we can
this is a very short application, can be disposed of, and my lord,
why so many cans are there?
my lord, other cans have disposed of.
Only
My
can
lord,
1, can 2,
can-
can 3, can 4 and can 10.
my lord, there are 4 cans my lord, which are pending rather. My lord, can 1, 2, 3 and my lord 10.
4 and 10, sir.
4 and 10.
Yes.
1, 2,
এগুলো
3.
তো আগের বারে এগুলো কি ডিসপোজাল হচ্ছে তাহলে তো দেখাচ্ছে কেন এগুলো
দেখি লিস্টে কি আছে?
আগের অর্ডারে তো 4 7 8 9 10 ছিল
So 4 my lord is there.
7, 8, 9, 10 were extension.
My lord, 7, 8, 9 my lord were extension
which
of
were-
my lord interim orders which have been all disposed of.
কোথায় 10 4
can 9 was disposed of on 1 5
Yes, my lord. 7, 8 were also disposed of, my lord.
on which date sir
My lord, I'll just give the dates, my lord.
can 7 disposed of on 2012
Correct, my lord, absolutely, my lord.
can 6
And 6, my lord,
disposed of on 7 10 can 5 disposed of on 7 8
yes, my lord.
let me regularize it first can 9 disposed of
And look at this.
So, what is can 1 of 2016, can 2 of 2016, and can 3 of 23 of 2018?
My lord,
3 of 2018
can 3, my lord, relates to my lord, can 4. I have asked for an order of recalling, my lord, of 27 September 2022.
Very good. Sir. Give me a second.
Yes, my lord.
একটু এসো তো বাবা
6, 7, sorry, 5, 6, 7,
5 টা আজকে পেন্ডিং দেখাচ্ছে
8 and 9, my lord, can go.
can 5 দেখাচ্ছে না না
And 5 to
5 দেখাচ্ছে না can 6 দেখাচ্ছে
Can four amended this amendment. This is our amendment.
দেখাচ্ছি না।
Bringing on records after the events of after 2015.
Can 7 দেখাচ্ছি। লিখুন on perusal of the
This application which we filed by
order dated 20/12/2024
again.
reveals
Yes, Lordship.
Between, page number
My lord, page 30,
30.
30. Original order, my lord, has been continuing with, my lord, also as directed by the Honorable Supreme Court as well.
Lordship, thereafter there have been changes, Lordship, I should.
Yes,
Justice
starting on-
Justice Korgupta's order.
yes.
Yes.
Then, my lord, Justice Bagchi's order. Then, my lord, all those.
Then, no, then what is your prayer in Can 4?
My lord, can 4, my lord, what had happened, my lord, though, my lord, can 3 was, my lord, prayer for, my lord, filing, my lord, the charge sheet, my lord, it was not shown to court that, my lord, they could not have filed the charge sheet, my lord, without putting it to court really, my lord, first.
No, sir. On 16/3/2025, 20,
These orders were subsisting. My lord,
the will have been liberty to proceed with the investigation, but they are restrained from submitting any charge sheet.
correct. Now, my lord, they submitted charge sheet, my lord, in pursuance to order of 27 September 2022. 27 September 2022 order, my lord, was contrary to all the previous orders. Therefore, my lord, we prayed for recalling, and that has been stayed,
27/3.
which I showed, my lord, page 28. This was contrary to the earlier orders.
The CBI has liberty to file charge sheet
Yes.
after
They
submission.
could not have filed. So this order is stayed. This is the interim order which, my lord, is continuing from time to time. Then,
This order has been stayed by division bench.
no, by our court, can 4 is that. So can 4, my lord, will have to be finally, my lord, decided, my lord, on the question of,
Mr.
my lord, recalling of
Banerjee.
the order.
Lordship,
Yes,
we need
Justice Korgupta's order was not to file submit charge sheet.
Correct. My lord, then, my lord,
Justice Samanto's order was permitting the CBI to submit charge sheet.
my lord, there are several other orders. I can show all that. My lord, then they went up, my lord, to the Honorable Supreme Court. Then, my lord, again, my lord, Justice Bagchi's order. If I show that, my lord, that will be better. Kindly, my lord, come to, my lord, on 27th. What is the, page 65.
page 65 of can.
Can-
Oh, can for.
Yes. Liberty is given to the CBI to file a supplementary
Yes.
in the writ petition enclosing proper
Correct.
charge sheet and memo evidence.
So this was not done. Without this, my lord, they wanted, my lord, to file, my lord, the charge sheet directly, my lord, before the court. And that, my lord, they obtained without disclosing to court, my lord, really, my lord, all the other orders. That is why, my lord, we came up for recalling of 27 September 2022, which is the order which, my lord, saw. Then the court stayed that order. So this is what has been continuing. Let's, can 4 is really for the
So
purpose
can
of.
4 can be disposed of along with the writ petition.
Let
No,
the,
my lord,
let,
I am asking, my lord,
all
for recalling
lordship-
of 27 September
lordship-
2022. It can be
lordship-
recalled and the writ petition can be heard. There's no
Lordship,
difficulty.
Lordship,
Mr. Banerjee, just a minute, ma'am. If the can 4 is taken up along with the main writ petition, what is the harm?
My lord, there is no harm, but, my lord, in the sense of, my lord, 27 September 2022 order has to go. Because that is, my lord, contradictory to, my lord, all the other
No, if
earlier orders passed.
you succeed in your writ petition,
everything. goes.
every order will
Everything
go.
goes.
Every will go.
But, my lord, 20,
Till now you are protected.
yes, still now I'm protected.
Up to at least up to the last day of January 2026.
Yes.
Let me
But-
fix the date for hearing
Lordship.
of the hearing petition.
But, my lord, 27 September 2022 can't survive. That's, my lord, an interim order which has to go.
Sir, survive or not, it will survive. That will be decided if the writ petition is disposed of.
My lord, if can 4 is also, my lord, taken up, then also, my lord, 27 September 2022 order will go.
No, Mr. Banerjee, I can.
My lord, I hope, my lord, I've been able to convey, my lord, what there, my lord, already, my lord, a set of, my lord, how, my lord, this matter is to proceed so far as.
Sir,
charge
Mr.
sheet-
Banerjee, I understand your
Correct,
contention.
correct. Well, that's, my lord.
As on this day, I'm not going to the nitty-gritty of the matter. As on this day, you are protected. At
Yes.
least up to the last day of January 2026 by this order, today's order.
By the interim order.
So if I fix a date for hearing of the main writ petition, I believe no harm will be caused to you.
But, my lord, I'm only on the, my lord, I'm not joining issue. I'm only on the question, my lord, whether, my lord, this 27 September 2022 order can survive, my lord, being contrary to our orders as well as the Honorable Supreme Court.
That will be decided at
Honorable
the time of
Supreme
hearing.
Court also said, my lord, that
No, sir.
the drill has to be followed.
And any other cans? What are those can 1, can 2, and can 3? What are those? What are those cans? Can
Well,
1, can 2, and can 3?
My lord, 1 and 3, my lord, are 3 is, my lord, that order, my lord, the can
By
3, which
CBI.
is by CBI.
Which is the application for.
That has been disposed of.
On the basis of that application, the
Order was
lease
passed
to-
27
lease to
September,
file
which
the
is, my lord, I have
supplement.
asked for recalling.
Which one, sir?
Lordship,
Page number.
28, my lord, I show.
দেখো দেখেছো ঠিকই বলেছেন।
My lord will
Acha.
find, my lord, can
Absolutely.
it,
Right, right.
My lord,
Let
which
me
was not found?
let me regularize.
my lord has seen that, my lord, not found.
Huh?
My lord, in the cost title of page 28,
Huh.
my lord will find, and this is one of our grievance, can 3 was not even before court. Not found. This is, my lord, our grievance.
No, third paragraph, can 3 of 2018 is disposed of. It is still showing pending.
It is, my lord, kindly look at, my lord, the cost title.
Huh.
Can 1, can 2, and then, my lord, can 3. They're not found.
I've seen that. Even then the can 3 is disposed of.
My lord, can 4 is, my lord, for the purpose of recalling of the order of 27 September 2022, which was passed on can 3.
Very good. Ashun.
And this was
Really
stayed
good.
subsequent.
On
Pending before the Honorable Supreme Court.
That they have to show
That
because
is there.
that is with
Orders
the
are there.
railways, not with us, Lordship. So let them bring whatever theirs. I saw
Very well.
instructions on that.
Whatever.
Whatever is
Tiny, my lord, fix it, my lord, any day. My lord, after, my lord, the vacation will come and show.
whatever is pending is
Yeah.
between
on that day I shall consider.
the
এবারে লিখো the affidavit two PM. As a specially fixed matter.
I'm so grateful.
হ্যাঁ
I'm grateful.
এই সব অর্ডার শিট গুলো বার করে দেখে নেবেন যে আছে
I'm yet to appear on behalf of the trade correspondent, my lord, led by Mr. Srishana
My
Bandyopadhyay.
lord, in this matter, I find, my lord, today morning I have gathered that the KMDA has been added as a party. And my learned friend has also shown me the service affected on
দেওয়া হয়ে গেছে
KMDA. But unfortunately, my lord, my office,
দেওয়া হয়ে গেছে
my
matter is
particularly the
matter is
losses.
appearing before this court for the first time.
yes my lord
Give me a second, sir.
my last order was passed
Sir, give me a second.
হ্যাঁ দিয়েছি এটা আমি কি করবো 26 মানে?
Yes.
I'll be requesting my learned friend to give me a copy. Though he has already served, but somehow my lord Losel could
Last
not
quotation,
trace it.
my lord,
Hmm.
on 5th March,
At my cost, I can take a copy.
my lord Justice Aniruddha Rai was pleased to direct us to file a compliance report.
Adjust the microphone. Yes.
This is our compliance report, my lord.
Give it.
Lord, in the meantime.
You are for the state.
Yes, my lord. I mean, led by Mr. Bandyopadhyay.
Since you lost is my land is asking for time. Lord.
Concerned senior deputy secretary as never should complete the process and disburse and put necessary fund according to the requisition made by the state and positive within 4 weeks.
Copy. আচ্ছা আমি দেখছি
Yes.
extra copy টা দিচ্ছি।
Lord, instruction submitted before the honorable court, Lord, at that point of time, the amount mentioned there which was sent for the vetting, the actual payment made much less, not. That's why not payment has been made. It is fact that the month of April, some payment has been given.
মানে
So, Lord,
I have annexed
since the matter is pending, Lord, I will come back with the latest position of the case, Lord, with the development made in this case. My land is paying for time, Lord. Can you consider that? Otherwise,
মানে there is nothing মানে remains, my lord. মানে মানে
No,
kindly look into my মানে last but one page, my lord. 3 crores 52 lakhs 51,295 was already paid, my lord. And that was received by my learned friend's client, my lord.
Take instruction. Take instruction, sir.
Lord, in open court, the instruction has been handed over to me, 5 crores 71 lakhs. Now he has given, they have given 3 lakhs 52,000. Now they are taking the advantage of the situation. Matter
No,
was
no, no.
adjourned only on the basis of the document. It was sent for waiting.
No, that was a tentative amount, my lord.
What was the amount?
5 crores 67 lakhs 53.
So according to you, you are entitled to much more. Ashun.
That was
It's on behalf
This is the contempt, my lord. Lordship, on the last occasion, I was told, my lord, that this matter is being is before the division bench. The matter is the division bench is in session of this matter, my lord, and this is the last order passed by the division bench, my lord, and the division bench has fixed this matter on 15th, my lord.
I don't know. Number, I don't know.
আরে নামটা লেখ না, অত কি লিখছিস?
Only learning AGP with Sanjeev Das and for the container. AGP. Mr. Sanjeev Das for the arrest container. 15th September,
My
for the arrest container. Should
I cannot say anything, my lord.
Item number 5.
I have been instructed to appear on with the response number 7. Private
This has been settled, my lord, earlier division bench, my lord, of this honorable court, my lord.
Is there any private respondent?
Yes, yes.
You are
I-
for the, Mr. Mahiti is for the private respondent.
Yes, ma'am.
Give me a second, sir.
Practical, this matter cannot be maintainable.
Wait, sir.
Response number 7.
Yes.
The PLRO, on 12th August 2025, the PLRO issued a notice to the SDO seeking for security to dispose of me from my property, my extra property, and we are living for more than 100 years. Before coming into that grievance, I need to elaborately discuss the fact. It is quite necessary, because the cause of action happened in 1953. The British grandfather and Gallard obtained a quantum of landed property about 20 days as Borgadar and pharmacy possessor. In the RS record, it is recorded in Lordship. And step to page number 26 and 27.
Page number?
Page number 26 and 27. The RS record. Page number 26.
Yes.
তার নম্বর 36 39 শ্রেণী আলী বর্গাদম গিরিশ দত্ত মাই গ্র্যান্ডফাদার
দাগের মধ্যে অত্র সংস্থ অংশ 1.
বর্গাদম গিরিশ দত্ত
What is the extent?
বাংলা সন 1330.
What is the extent of your occupation?
I have obtained this from one Obrendranath Maiti as Borgadam. Bhajan.
You are the owner of 62 decimal.
16 decimal and my granddad 4 decimal. His name has been recorded as Onumotito. Next page, your lordship, page number 27.
Dag number?
36 35 বাস্তু মন্তব্য ঘর 2 অনুমতি দং কাদম্বনী বেওয়া মাই গ্র্যান্ডার
Yes.
Since 1923, your lordship, without any interruption, where my ancestors are living there by constructing dwelling house and by earning livelihood by cultivating it. By lineage, we have inherited the property. Hereupon, your lordship, suddenly, all on a sudden,
Where is your pleading to that effect?
lordship pointed Texas there.
Where is your pleading to that effect? I want to know.
I didn't plead to that.
What is your pleading? Where is your pleading? There is a paragraph number 2 and 3.
Paragraph, page number 4 of the petition, paragraph number 2 and 3.
That your petition since 1923, the ancestors of your petitioners had been in continuous, uninterrupted, and peaceful possession of the landed property, exercising all rights, interests, and have established their very good. Then what happened? And subsequently, your petitioners have acquired the property by way of inheritance from their ancestors and have been residing thereon. Absolutely. Very nice.
All on a sudden, in the year 2018, your lordship,
Hmm.
the private respondent approached before us, informed us that by virtue of a Pattanama, which has been issued in the year 2001-2002, after 17 years, they approached before us and informed us that they have been issued through by virtue of Pattanama, the entire land has been given to them.
In plot number?
In plot number, which is same plot number, of course.
3639 and 3635.
Right now, LR plot number 4548 and 4544. Page number 4, I have make a chart, your lordship.
Page number 4.
Page number 4, I make a chart.
Yes. Very good. Yes, you make a chart.
After 17 years, they approached me. They told me to leave the property. As usual, I refused. As a consequence, they approached before the Learned Civil Court Junior Division Takti in the year 2018.
You are the plaintiff there.
No.
They are the plaintiff.
They approached before.
What is the prayer? What is the prayer in the suit?
For possession, your lordship.
For recovery of possession.
Recovery of possession.
Have you annexed the copy of the plaint?
Well, I think the document. Hereupon, your lordship, I am pausing here. No, your lordship, one thing is to mention. On the said suit, this is pending, this is subjudiced under Kartik Court. I beg your lordship to kindly come to the order. page number 56, annexure P5, page number 56. I have annexed the order. Tada.
Yes.
Fixed 8 December 2025. Sorry, 18th December 2025 for hearing of non-maintainability petition as filed by defendant number 2 and 3. Us. Dated such and such. Written objection, if any, in the meantime. But is still subjudice. And now I am pausing here, Lord. And I am shifting to the next phase of this case here. In the meantime, the same year 2018, we found that when in 2001, 2002, when the patta has been given to them, at that time they were minor. We have approached before the learned LRTT on the same year, challenging the patta nama on the ground that the minor could not be able to get patta. We have initiated a separate process on the basis of only that ground. You notice the order is there. Annexure P6, page number 58.
Disposed of, withdrawn.
The matter, but directing the SDO to deal with the entire issue. On what ground? Whether the
No, the tribunal, before the tribunal, you have withdrawn. Liberty was given to file a phrase representation for annulment of patta. That liberty was given.
Accordingly, phrase representation has been made before the SDO.
Huh.
SDO started a new proceeding, your lordship.
Huh.
Now, while adjudicating the matter, the SDO directed the BLRO to, by making an inspection, file a report. We are lacking the report, but the content is reflecting in the order of the SDO, your lordship, dated 8 October 2020, page number 61, annexure P6, same annexure, your lordship, page number 61.
Huh.
Page number next, this is the order 8/10/2020. Next page, there is the portion, your lordship. First page, page number 62, next page. And report from BL and LRO, Namkhana, also supported the claim made by the petitioner Subrata Doctor, that is me. It stated that on verification of original patta proposal, PIN number 07/2001-2002, it is found that there was 20 number of beneficiaries whose name was proposed for patta and which was approved by this office of the undersigned on 18th April 2002. And then this is important, and the name of two pattadars, that is Rumpachana and Gautamchand,
But the private respondent
was not found as beneficiaries of the above mentioned patta proposal. Field inquiry report dated 16/9/2020 also showed that the petitioner is a possessor over the whole shoot plot areas, that is 0.20 acre. 20 decimal.
Yes, then what happened, sir?
Same. The order dated 23rd 11/2020. Its planted SDO has taken some observation, inadvertent observation. Instead of the report of the PLR, such kind of report of the PLR. Defective portion in notes. Now, as per provision under section 49(1), subsection 1 of WPLR Act 1955, there is no mention regarding age of the patta as eligibility criteria for getting any settlement at the material point of time. Effective portion, point number 8 of the observation. I'm reading it out in lordship. Not only that, mere possession is not the only.
Ultimately, SGO declined to cancel the patta.
Without any justification, your lordship.
But that is not subject matter of this court.
We challenged the entire observation before
the tribunal.
ADM and LRO. He also upheld the same observation. Again, we challenged the order of the SDO.
Where is that order? ADM order is page number?
Page number 65. Annexure P7, page number 65.
Those are the entire word. Ultimate order is a order date 8/9/2022.
Yes, 8/9/2022.
That is the order.
Same observation. No objection.
That is the order of the ADM.
Yes, sir.
Dismissing your appeal.
Yes, sir.
Very good. Then what happened?
Again, dissatisfying with the observation of the which we
You approach the tribunal.
Tribunal.
Very good.
Tribunal also upheld the same observation.
Tribunal of the same observation.
Finally, we approached.
What is that order? Page number 70.
Page number 69.
Page number 70 is the order.
7 December 2023.
Challenging this order, you prefer appeal in the division bench. Yeah, preferred it petition division bench.
Yes, sir. In this honorable court.
Very good. That has been still pending or it has been disposed of?
Order of the honorable court. Page number.
Your writ petition was dismissed.
Lordship.
Your writ petition was dismissed.
Oh, my lord.
That is page number 74 and 75.
Page number 74. Page number 74. And page number 75. Annexure P. That is that. In each and every case, your lord.
Now I understand. Now what is your grievance now?
I'm saying that. Each and every cases, I have been approached before the LRTT on what now? Whether being a minor, the private respondent is eligible to.
Sir, try to listen. Try to listen. Rightly or wrongly, you have failed in every forum. Now, what is your grievance?
Coming to that, not a single forum has deeply dived into that particular portion, that the report of the PLR, the fake patta upon fake patta. In that regard, your lordship, we have also made a RTI application, your lordship. Kindly come to page number annexure P9.
No, sir, I will not come anywhere if you do not reply to my question. After dismissal of your writ petition, challenging the order passed by the tribunal, your liberty is not before the your relief is not before a single bench. Then why you have come before this court? That I intend to know first.
When this matter is subjudized regarding the position, when this matter is subjudized under Calcutta court, maybe there is chances that I will get adverse position. There is chances. They have issued an inadvertent notice that they are going to dispose of me from my property by 2 weeks. But the entire possession regarding issue is subjudized under Calcutta court.
So go and file an injunction there.
Your lordship, today they are going to. This is a violation of fundamental rights, your lordship. Nowhere in the entire.
As on this day,
entire series of.
Sir, try to visualize. As on this day, you have no material to show that their patta in respect of the aforementioned 2 plots have been cancelled. Rather, their patta has been affirmed by the BLRO, affirmed by the ADLRO, affirmed by the tribunal, and affirmed by the Honorable Division Bench of this court in your writ petition. Now, what do you want now?
I appreciate this fact. But this is also a matter of fact that in the entire proceeding, in the series of proceedings.
Even then, Sir, even then, if you have, even then you have any grievance, you go before the civil court.
Nobody has focused into the authenticity of the Pattanama. They in the RTI reply.
Then what is your prayer then?
My prayer is to just to set aside the inadvertent notice, your lordship. They are going to
Inadvertent notice where? What is that? Let me see.
Annexure T11, your lordship.
Annexure
T11, page number 83.
page number 83. So they are going to deliver possession to the pattada.
Yes. How? Possession is going on, your lordship. Regarding the possession, the matter is subjudized.
There is an act, you know specifically that.
50, yes, your lordship.
So you can file, you can file a suit for declaration injunction. Take down.
By today they are going to evict me, your lordship.
Not even assuming the fact, my lord, division
Your
bench.
lordship, your lordship.
Mr. Maiti, I am going to dismiss the writ petition. If you want. matter.
Your Lordship has directed the state to file a report in the form of affidavit. May I please? Your Lordship?
Please, Your Lordship, my Lord had been pleased to grant me a week's time, my Lord, to put in an exception to the report. If Your Lordship recalls, my Lord, the
On behalf of the respond numbers 1 to 4,
My Lord.
uh, which for the petitioner.
I'm for the petition. I mentioned this matter, and Your Lordship was pleased to allow me mention 3 matters are there on the grounds of urgency because the PWD and the block development officer has directed to demolish my property. And that's the 3 matters are same, the identical. Now, what happened, very
So which matter will be taken up?
C is the identical. First matter is taken up because 3 matters in 3 different petitioners and the plots and the premises.
7, 8 and 9 are same. So tell me which tell me which matter I'll take up 7.
Yes.
Give me a second. এই 8, 9টা একটু তুলে দিন তো ভাই।
সেটা মনে দাদার আছে।
আসুন।
Order is under challenge.
ও আমি হ্যাঁ না ওনাকে বলছি সরি সরি। এখানে এখানে আমার
Infractions.
give me a second, sir.
I need to mention something. Well, the day when I mentioned the matter, that day I got information in the evening, the demolition has done.
So it has become infructuous.
Infructuous matter. Because other points are there, because they have demolished without taking the report of the acts of right to fair competition. That your lordship is aware of the right to fair competition. Even if I am not the owner of the land where my lord I constructed my shop rooms way back in my lord more than 20 years back, when I am continuing the I am an artisan or to that effect. And when
You have been removed by under the provisions of West Bengal Highways Act.
so the West Bengal Highways Act, that also, my lord, that is, my lord, so long, my lord, the right to fair compensation is there. So, my lord, even if, my lord, National Highway Act or the State Highway Act, both are, my lord, the right to fair compensation is above that, my lord, the overriding effect is there. So that has
When you encroached, you take prior permission.
no. So, my lord, the more than that has been, my lord, more than 30 years.
So what is your prayer now?
That the prayer here, my lord, is to
It has been removed. Your encroachment has been removed.
Yes.
Already
So already infructuous.
infructuous.
To file appropriate application.
They prefer an appeal. Appeal has been dismissed also. That when you are passing this order without taking care of the right to fair competition act, that is their manner in my writ petition. Because I have challenged all these the proceedings.
You are unlawful encroachers.
That is their manner the act.
Lordship, the BLR's report is
Yeah.
You are unlawful encroachers.
That is not that prayer.
You are unlawful encroachers.
See the trade license.
What more I will see, sir?
Holding number has been given.
Then everybody will come and sit on the road. Then I will carry on business.
The road itself. No matter that, your lordship will find on the basis of this private respondent file a writ petition where the order passed.
Sir, you are
that
building.
India's address has
Sir,
been-
you are building your home on air. You are building your home on air.
I really appreciate what this act.
I've seen. Doing business, everything you have been
in this case.
dismissed.
Section 3 provides, my lord, this.
Very good.
Again, my lord, I appear for the petition.
Who is for the petition? Who is your other side, sir? English.
We have served, my lord, we have also intimated. They have received, my lord.
Then what happened to them? What are your other side?
It has to be the state. The order, the impugned order, my lord, was issued by the additional district magistrate.
It is a case of mining.
Yes, sand mining lease. If your lordship remembers, my lord, I had said.
Why nobody is appearing?
Truly is for the state, my lord, she was served. I'm being told by my junior. I do not know why she is not appearing, my lord. She was duly informed also, my lord.
আসুন, the affidavit of service has
একটু প্যাটার্ন লসিপ আছে
take some breath, take some breath.
সাত হচ্ছে
You alone appearing?
সুপ্রতিম ধর
Where is Mr. Dhar?
হি ইজ এনগেজ ইন কোড নাম্বার 10 লসিপ
Lord, may I start, Lord? I'll be requiring 10
It
to
will be taken up at 12:30 p.m.
Loss.
Please inform Mr. Dhar.
লসিপ
এটা কত নম্বর আইটেম ছিল গো?
12:30.
Just a minute. 12:30 p.m. sir.
লসিপ
Please ensure the availability of Mr. Dhar.
লসিপ
Item number 11.
Who's for the state?
Lord, I have served everybody, they have received.
এই তো আচ্ছা
This is my affidavit. This is my affidavit service.
Is there any private respondent?
Yes. I have also served them. I have also served them, they have received it. Now the affidavit service is 26 pages. Because of track reports are there. But here in fact, Lord, the High Court order has been violated. And especially passed by your lordship.
Give me a second, sir. Give
Yes,
me a
yes, yes.
second.
Yes.
I'm really disturbed because of the absence of the learned advocate for this state.
This is very embarrassing position.
In every day, this is happening.
This is very embarrassing position. Very much embarrassing position.
Mr. Mukherjee, you are also in panel. There are junior panel, senior panel.
Yes.
So when my recollection goes,
Group B, Group C, then junior government advocate, then senior government
so many, why the lawyers are not appearing?
I will convey to your lord.
You are in group A.
I'm entitled 1 million.
He can
And
accept.
so far my recollection goes, the panel is very long. Then why nobody will appear?
And I will intimate. Somebody has been engaged. Ma'am. So, Dada achen naki na?
He or she has to come. মুশকিল ব্যাপার হলো।
My learned friend has come.
Yes, my lord.
I think he's
You are for?
I am for the state responsible.
So what is your predicament? Why are you not coming?
বলুন।
You are for the state.
Yes, madam.
Who is for the private respondents?
I have served. They have received.
Private respondent নাম কি আছে?
There are 2 private respondents, I think. There are 2 private respondents.
10 and 11.
10 and 11.
$492, $489. 492. Place your case, sir.
Yes. Lord, today, my lord, I have come before your lordship because of the notice they have issued on 21st my lord, August 2025 for demolition. That was not annexed because my lord, after filing of this writ petition, my lord, they have issued the notice. Lord, you are in fact, my lord, the Honorable High Court.
What is the subject matter of the petition?
May I submit? Lord, there was a proceeding
The order dated 22nd April 2025.
Lord, I'm coming. Lord, I'm coming. Let me, Lord, give me 2 second time, Lord.
Very good.
Lord, there is a proceeding initiated, Lord, under section 10 of the West Bengal State Highways Act, your Lordship knows. 10.1, 10.2, 10.3, 10.4. When the 10.3 was issued, Lord, then, Lord, we approached before this Honorable Court and filed a writ petition, challenging that notices that we have not been given any opportunity of hearing
Before the SGO.
before the SDO. Challenging that matter, Lord, our writ petition was filed, but the writ petition was heard by this Honorable Court, and your Lordships kindly have a look of the only one page, that is at page 93.
Page number 93. Yes.
Without opportunity of hearing, Lord, the SDO has already filed the passed the order.
Challenging that order.
Challenging that order, Lord, we filed the writ petition.
Huh.
This is the writ petition. This is the first order at page 93. Your Lordships kindly have a look of the page 94.
Yes.
There is a stay of operation of the order dated 6th August 2024. Your Lordship will find
Yes.
this order was stayed by this Honorable Court on 12th September 2024.
Huh.
Then next, Lord, page, your Lordship kindly have a look of the page 95. That order of stay extended till, Lord, that is vital, till 30th April 2025.
Huh.
30th April 2025 or until further order, whichever is earlier.
Huh.
Now, when this order is still in force, Lord, the affiliate authority, that is, Lord, DM, Lord, passed the order. Your Lordship kindly have a look of the order at page, Lord, 116.
No. I'll go to that. I'll go to that. Come back to page number 93.
Yes, 93, Lord. I'm coming back. 93.
Read the first paragraph.
First paragraph.
Yes.
93, first paragraph. Since it has been submitted by the first
Page number
paragraph,
93, sir.
yes, it appears that during the pendency of this writ petition, an order dated so and so was passed.
Huh.
Just
So, which then now come to 93.
yes,
94.
94.
Stay order was passed on the order date 6th August 2024.
6th August. 6th August. 6th August, this order was passed by the SDO.
In 10.3 proceeding.
10.3 proceeding. Right. Thereafter, this order was extended from time to time, and lastly, it was extended not on 6th March 2025 at page 95.
Up to 10.
Up to 30th April.
So this writ petition was prepared by you?
Yes.
And who prepared the appeal?
We prepared the appeal during the pendency of this 10.4. Since there was 10.3 order, we prepared the appeal. During the pendency, in this appeal, your Lordships kindly have a look of the page 116. 116.
116.
116. 116, your Lordship will find the date of the order, order number 5, left side. Your Lordship will find
22/4.
Yes. 22/4/2025, the Lord District Magistrate under the authority under section 10.4, Lord passed the order wherein Lord 6 August 2024, last paragraph, your Lordship kindly have a look at that. Thus the impugned order, as your Lordship got it, last but 4 lines.
At page 116.
116, last but 4 lines, 4 lines.
Yes, I got it.
Thus the impugned order dated 6 August. That is the order of the SDO. 10.3. 6 August 2024 of Subdivisional Officer Kakdeep is hereby upheld. When this was stayed by this Honorable Court and was effected on the very date, 22nd April 2025.
The subject matter of writ petition is the order dated 6 August. That was stayed.
Order was passed on state.
So you have not sold the order to the High Court?
Yes, we have. And thereafter, Lord, very Lord, interesting. After that, that writ petition was finally taken up by your Lordship.
Then what happened?
Yes, your Lordship kindly have a look of the page 117, next page. Your Lordship has passed the order. In fact, after considering the matter, your lordship has been pleased to remand back the matter to the SDO under 10(3) to decide afresh
No.
after giving opportunity.
Writ petition is dismissed.
And thereafter, my lord, thereafter,
Huh.
thereafter, my lord, kindly see, there was an order of status also passed by your lordship. My lord, your lordship, kindly have a look at the last at page 122, 122.
Who is the respondent number 7 there?
But seven is the
Private response.
SGO.
7, yes. SDO. There was two directions.
Give me a second. Participating in the proceeding under 10(3).
So
Yes.
that writ petition was disposed of by passing this order. Thereafter, Lord, the SDO has initiated the proceedings. Your lordship, can you have a look of the page 124?
Oh, then at the time of hearing, why you have not
We
said
have
that
produced. We have produced all the documents.
before me?
No, before your lordship as well as before that.
No. When it was disposed of?
No, it was
5th
disposed,
May.
but they have communicated later on. Lord, your lordship will find the order of the district magistrate passed on Lord 22nd April, but communicated after the matter was disposed of by your lordship. This is the main problem. And then, my lord, again, in terms of your lordship's order, the SDO has, my lord, initiated the proceedings. Lord, your lordship, kindly have a look of the page 124.
So
124.
which order is under challenge then?
Yes.
Which order is under challenge?
Here.
Huh?
Lord, here the learned district magistrate. Learned district magistrate's order is challenged here. 22nd April 2025. Lord, your lordship, kindly have a look of the, it will be clear to your lordship. 124. Page 124.
Huh.
124, your lordship, kindly see that. The SDO has issued the
Notice has been
notice to us.
issued. This SDO notice has been issued.
Notice has
pursuant
been
to-
issued, hearing has been done, judgment has been reserved.
No. This notice was issued pursuant to my order.
Yes. And the matter is still pending.
Huh.
In the meantime, DM has passed the order, during the pendency of the stay passed by this honorable court.
Upon hearing all the parties.
If the DM does not know, will not hear anything, he will pass the order. They also knew, Lord, the order passed by this honorable court.
14th May.
14th May, the notice was issued, fixing
Pursuant to the order passed by me.
Yes.
And when the DM passed the order?
Not that long before.
22nd of April.
22nd of April.
Oh.
State is representing the before your lordship.
Yes.
The
What have you got to say?
My lord, actually, my lord, on 22nd of April, my lord, all were present, my lord.
Yes.
They were well aware, my lord, about the passing of the order. In spite of that, my lord, that has not been placed before my lord hearing.
In presence of
In
the
the
learned
petition.
advocate appearing for the state respondent is there. We produce the documents before there.
My lord, kindly see. My lord, page 116.
No, sir. What I'm on? What's your good name?
Ashim Kumar Raut.
You are there.
Yes.
Yes.
Then why you have not intimated when I was passing the order in WPA 20204?
Right.
Why you have not intimated me?
Before that, when the order was passed, order was communicated after that.
Where will we get that?
my lord, that I have stated in my petition, I'm showing to your lordship.
Mr. Rouse, try to understand.
Yes, yes,
I disposed of the writ petition on 5th May.
Yes.
yes,
The district magistrate passed the 10-4 order
April,
on 22nd April.
but it was communicated after 5th May.
Question of communication does not arise.
Otherwise, how we will know the order was passed? Otherwise, how we will know?
Where is the letter of communication?
Your lordship kindly come to 111. This is the letter of communication, 15 July. After the order was passed by your lordship, 5th May, your lordship was pleased to pass the order. They have not served me on 15th July.
Take down. WPS 7472.
Yes.
It is whose order?
7.72, blood, that is your lordship's order.
No, it is 20204.
No, that is their matter. That is the matter of the private respondent. And here, my lord, your lordship will find এত দ্বারা জানানো যাইতে যে মহামান্য কলকাতা হাইকোর্ট ও মহামান্য জেলা শাসক দক্ষিণ চব্বিশ পরগনা। This is under challenge before your lordship.
No, WPA number 747.
That is the petition filed by the private respondent. On the basis of that, my lord, the entire proceedings were initiated.
So what is the stage of the SDO proceeding of the SDO?
SDO, my lord, the hearing has been concluded. 2 notices have been given. 2 dates were fixed. We have
You are appeared
there.
I am for the private respondent.
Why are you so early?
My lord, I am tendering my apology, my lord, from my lord Saskia Centenary building to my lord this. I just faced my lord.
You tell me I will reach there
No, no.
at your convenience. If you are, what have you got to say?
My lord, the latest status, my lord, report is tomorrow is
So he prays for quashing of the district magistrate order.
my lord.
However, he has shown my order where I permitted you all to participate in the before the SDO.
My lord.
So naturally DMA orders will go.
My lord.
আসুন।
But earlier occasion, my lord, in the self-same matter, I took the leave from your lordship's court to move. But on that day, your lordship, my lord, was not in the court, my lord. I moved before Justice Chandru. But the self-same notice. But my contention is that but a notice under section 10(1) has been served upon my clients. It is the specific contention, my lord. No opportunity of hearing has been given. No procedure has been followed. Straightway, my lord. If your lordship kindly straightway come to my lord the notice, your lordship will find that straightway, my lord, directed for removal. But kindly see the notice.
Where is the notice?
Yes. But the notice your lordship.
Mr.
will-
Pandit. Mr. Mukherjee.
Yes. Now, my lord, your lordship will kindly turn to, my lord, page 8, paragraph 10, my pleadings. Because, my lord, earlier occasion, when I moved that writ petition, your lordship specifically before granting the leave, asked me whether I have pleaded that, my lord, the procedure has been followed or not, whether notice opportunity of hearing has been given or not. And the pleadings will be at page 8, paragraph 10 and 11.
যেটা পেয়েছে ওই ইঞ্জিনিয়ার যারা বলছে পাইনি কপি
There is no private respondents. But on the basis of the complaint of the private respondents.
No. What happened, my lord, I'm telling your lordship. A writ petition has been filed, my lord, and in that writ petition I have annexed before your lordship's court. Kindly turn to, my lord, page 30, annexure P4, page 31. This writ petition has been filed by one Joydev Bera and Oboni. Joydev Bera and Obonti Kaur.
Alleging encroachment by you?
No. By one, page 33, Animesh Maiti.
By one Animesh Maiti.
In that proceedings, my lord, our order was passed that if they ultimately the usual order, if ultimately the grievance is found genuine, then 10-1 proceeding has to be followed. Now, on the basis of that proceeding, initially the respondent authority did not take any steps. A contempt petition has been filed. Now, my lord, against that, an appeal was preferred. In the division bench said that we will not interfere, but the authority will follow the procedure. That means, we're providing opportunity of hearing, my lord, the 10-1 procedure has to be followed. That order I have annexed. Now, what happened, my lord? I was not a party. I don't know anything. Suddenly, my lord, a notice has been, my lord, given to the conspicuous space of the shop room, my lord, page 30. In that notice, my lord, without providing opportunity of hearing, without following procedure, my lord, they asked us to remove, my lord, within fortnight. Now, my lord, in earlier writ petition, my lord, this order was passed by Justice Chandra, my lord. On that day, the determination has been given to Justice Chandra. My learned friend appeared along with Supratim Dhar. But they are also, my lord,
in this writ petition?
No, my lord. No. But earlier occasion, but total there are 30 writ petitioner. Total 30. Earlier occasion, my lord, 24% moved, and these are the rest 6%. Because, my lord, in earlier writ petition, court observed that the interim order will be limited in respect of the writ petitioners. I kindly see that order once.
Yes.
Now, my submission before your lordship will be, as in earlier writ petitioner, there was a direction, my lord, that the interim order will be effective to the writ petitioner. Rest 6%, my lord, they have came up before your lordship's court now. Now, what happened, my lord? My lord, the honorable single judge as well as the honorable division bench observed that the procedure has to be followed. What is the procedure? If I have encroached, they have to provide me an opportunity of hearing. I will produce document. If I fail, they may pass an order. If I agree, I have a remedy before the appellate authority, district magistrate. Now, my lord, they cannot, invoking section 10A(1), ask me to remove the, or my lord, kindly see the word, you are requested to remove the encroachment and restore the highway in its original position within fortnight. My respectful submission before lordship will be that this matter be heard along with, because now that matter will be heard by your lordship. Kindly heard this matter, both the matter together.
Which one?
This matter also, because interim order was limited period, my lord. And my lord, highway that, if your lordship. Kindly see 10.3. After notice to the person.
Give me a second.
I'm sorry. You have to take করে দিলে হবে।
Mr. Mukherjee, kindly place section 10.
Yes. I've seen my lord. Your lordship will say my lord 10(1)(c).
No, why see 10-1?
Sir,
You read from 10-1.
if any person is found to have make an encroachment on any road, street, pathway, land is declared to be by the highway subsection 1(3). But first one causing for a moment, this declaration 1A is not been published that I have pleaded. 2. Makes an encroachment on a highway in contravention of the provisions of section 8. C. Does not remove an encroachment on expiry or cancellation of the permit granted to him. Then the highway authority on any official authorized by him on his behalf shall serve a notice on him requiring him to remove the encroachment and restore the highway original position within notice. Then, if the encroachment is not removed within the time specified in the notice, the highway authority or the authorized officer under subsection 1 may make an application to the executive magistrate having jurisdiction over the area, not being the district magistrate for removal. 3. Such magistrate may, on receiving the application and after notice to the person responsible for the encroachment. I harping 3 because
So 10-3 has not 10-3 stage has not yet
now
reached.
what police is doing? Police on the basis of the same mallet is miking and came already demolished to saw.
No.
Yes, but that is doing.
Mr. Mukherjee, try to understand.
Possibly
10-1 10-1 says service of notice.
I am what I am on.
Please, 10. If I am wrong, please correct me. 10-1 says service of notice. If you do not comply with 10-1, then 10-2
magistrate
proceeding will start 10-3. And in 10-3 you are entitled to get notice.
Therefore, before unless 10-3 invoke, these officer without the help of the police authority can't remove me. Kindly make it clear.
Absolutely.
Kindly make it clear. I'm out. Kindly make it clear. That is my submission.
10-1 does not presuppose anyone.
Absolutely. Kindly make it clear that without following 10-3, they can't remove me. On the basis of this notice, but police can't remove me.
So what is the pleading to that?
Yes, kindly see.
Paragraph?
But first of all, I have stated, but page 10, 11.
Page 10 and 11.
Page 10, 11, 12. I said 10-3. Paragraph 12, kindly see. Page 8.
Page or para?
Sorry. Page 8, paragraph 12. Page 8, paragraph 12. 10-3. I am also on that. Let them follow 10-3.
Place.
Your petitioner states that under section 10(3) of the West Bengal Highways Act 1964 provides that before evicting a person, a reasonable opportunity of hearing ought to be provided to such person, and if such person is aggrieved by the order of eviction, remedy lies under 10(4). Therefore, let them follow 10(3). With this notice, the police cannot remove us. Kindly make it clear, they have to follow. I will be out of court. That is my only submission. That is my only submission.
Well, it's premature. I submit. It's premature.
But this argument has been advanced before Justice Chandra also.
So what? That interim order is not binding upon my lord. Interim order cannot be binding on coordinate bench.
It's a premature application.
Absolutely premature.
Kindly make it clear that on the basis of this.
What is that?
This is report, my lord.
What report you have submitted?
10-1 proceeding and.
Yes. Now kindly see if that be so. My lord, kindly see they have already.
Give me a second.
Yes.
No demolition has been started.
Demarcation will be held, then they would get a chance of hearing.
In front of me.
Then they would get a chance of hearing. Then they would get a copy of the report. Then they can take the objection. This is absolutely premature.
This submission has been made by Mr. Dhar before the other coordinate bench. Now, my lord, kindly see what they have done.
This is in connection with the 19240. Please.
No,
give me a second.
Different matter.
No, in the division bench.
kindly see paragraph 8. Without intimating me, and this 18 I will not come. এখানে কি পিটিশনার আছে দেখতো? দেবব্রত বাগলি।
Now, my lord, kindly come to page 102 of the writ
Madam,
petition.
madam, I have
102.
something to say.
That
Let
is
him
the
come.
Honorable Division Bench direction. My lord, kindly come to my lord, page 102 once.
But I'm agreed.
Only I will place.
In accordance with
My lord,
law.
only I will place. My lord, kindly ask my lord, Mr. Mukherjee, that duel cannot happen, my lord. I'll just place only para 8, 9, 10 and 11. Only. It is true that if the petitioner himself is an encroacher prior to remove the encroachment, I'm skipping over. Then kindly come to 9. Further, the learned advocate for the appellants points out that there are more than 32 shops and other establishments on either side of the road, and selectively action has been taken only against 5, which include the appellants and the writ petitioner. Then para 10. Since the procedure under the Highways Act has already been invoked and notice under section 10(1) has been issued, the officer authorized under section 10(1) has to proceed in terms of subsection 2 of section 10, and thereafter the executive magistrate should proceed in terms of subsection 3 of section 10 of the Act. Since there is an allegation that there are other establishments, shops, houses, so division bench has said already you are to follow 10(1), then 10(2), then 10(3). So already protection is there.
Take down.
Before that, madam, kindly hear me 2 minutes. If your lordship kindly. Kindly state.
What more I will hear, Mr. Mukherjee?
If your lordship.
Your application is absolutely premature.
Your lordship hear me. If your lordship.
Yes.
Now, madam, kindly see the one report has been handed over to your lordship. Now, madam, kindly see the report. This report dated 26th August 2025.
Yes.
Now kindly see, but paragraph 8. 18 I will actually got it, paragraph 8. That the demarcation report of the BLR of Sagor, wide is memo number such and such, shown total 18 numbers of structure have been encroached the PWD roads. Now kindly straightway come to that malad report. But your lordship will find 1, 2, 3, 4, 5. Page number 5. A, B, C, D, your lordship will kindly see.
Does not bear any page number.
My lord, if your lordship consider assistant engineer.
Yes. More. Map.
This one, my lord.
Yes, I got it.
But kindly see the names. But total A to Z. Now kindly see the writ petitioner's name. Your lordship will not find any name here. Not a single name.
Very good.
Now, my lord, kindly, may I just complete? Now, what happened, my lord? Mr. Dhar is of the view that, my lord, if Mr. Dhar assures that they will follow 10(3), I mean, the remote, my lord, locality.
Listen to my order. I have understood, sir.
Only one thing, my lord.
No more.
Another last thing, if your lordship permit me.
No, sir.
That without.
Not at all. Take down. The affidavit of services filed today on behalf of the writ petitioner.
Kindly
is
record
taken
that
on record. Stop para. Both the writ petitioners and the private and the Less than good.
Extremely good.
Pass over.
Yes,
Mr.
I appear for the
Dhar?
petition.
Mr.
Dhar
Dhar
was
to
there,
ছিলেন এই
he
মাত্র।
was there in the last matter. My lord, he will join in, my lord. He's
He was there,
He's online.
এই Mr. ধরকে নাও।
কানেকশনে কিছু প্রবলেম হচ্ছে?
ফোন করে বলে দাও।
হ্যাঁ? Call him, go outside the court and call him to ask him to join.
Lord, may I start in the meantime?
Yes, sir. Definitely will start.
I'll try to be as short and as precise as possible. Lord, your lordship will find, my lord, the challenge.
Give me a second, sir. Yes.
Yes. Your lordship will find the challenge in the writ petition is with regard to a suspension order of my sand mining lease. Now, my lord, my bone of contention is that the order of suspension is not only bad, it is premeditated and pre-motivated. And it is not in accordance with the agreement, that is the sand mining lease agreement, which has been signed between the parties. Here, my lord, the district magistrate Bankura, in an auction, my lord, I was a successful bidder, my lord. I was granted the Bankura one or the Sonamukhi Ghat. Now, my lord, first I'll draw your lordship's attention to the show cause. Thereafter, my lord, I'll show you the suspension notice.
What is the allegation against you?
That
Illegal
I have-
mining.
Illegal mining.
Illegal
Why?
mining.
Why? Because I have not erected walls. So I have a defense to that as well.
Very good.
My lord, kindly takes up first the show cause notice.
Page
That is
number?
at page 75. And I'll also show the reply to the show cause.
Page number 75. Give me a second, sir.
Show cause. Yeah, I'm sorry. No, show cause is at page 76. 76.
Not 75.
No, 76. I'm sorry.
It's all right.
Your lordship will find. Now, I'm sorry if I'm rushing up, my lord.
No. Don't be so hurry.
No.
Yes.
Yes. Your lordship will find, my lord, the show cause notice at page 76, my lord, your lordship will find, whereas on the basis of the findings received from the subdivisional officer Bishnupur Vide such and such, dated such and such, it appears that illegal sand mining activities were carried out beyond the location of leasehold area of.
What I said, illegal
Yes.
activity. I said,
Now,
purely
my lord, the answer to this is from page 76.
illegal
Sorry, sir,
mining
I'm sorry,
beyond the
sorry.
leasehold area.
That's the allegation.
Then what happened?
Now, my lord, kindly sees to this what I reply. One of my representatives acting on my behalf.
ভুলবশত আমি অন্য মৌজায় বালি সরি have admitted.
Yes, but with a rider, with a caveat which I'll show that I am protected by a particular clause in the agreement. Demarcation করিয়ে আমার দেওয়া খুঁটিগুলো হারিয়ে যাওয়ার কারণে. But what is the reason of হারিয়ে যাওয়া? That's the flooding of the river bed.
I understand. Then what happened?
Now, my lord, after this reply, my lord, they straight away issue an order of suspension. That is at page 78, which they could not have.
Why?
I'll show, my lord. I'll show from the agreement itself. That is why I say it's pre-motivated.
If it is found that you are carrying on mining activity illegally beyond your leasehold area, they will not issue suspension.
I'll show. They cannot. my lord, They cannot. Why they cannot? That I'll show from the agreement itself, because the agreement is binding on both the parties. So now, my lord, your lordship is finding the suspension order.
Been suspended. Yes.
Yes. Now, my lord, kindly comes to page 51 onwards. That is part 9.
51.
That is the lease agreement which we both have signed.
Just a minute. This order is under challenge.
The suspension order is
Suspension
under
order is challenge.
Yes. Why I say the suspension order is bad, my lord, now I'll explain. The lease starts at page 22.
দাও তো বাবা ওই যে মাইনিং রুলস 2006 টা দিন পেজ নাম্বার
My lord, may I please?
Now the lease starts at page 22. And my lord, the relevant portion, as your lordship knows, my lord, it's a time-bound process. The tenure is 5 years, and my tenure is going to end in December 2025. Now, my lord, kindly comes to page 51. It starts. It is the general provisions. Provisions for what? If a breach is committed. Give me a second, sir. Give me a second. As your lordship found it, my lord. Please give me a second, sir. I'm sorry. Yes. Yes. Now, my lord, kindly comes to page 51. It's the general provisions, my lord, where my lord, the breach of conditions is there, one. Now, lordship kindly comes straight away to page 52. That is condition number 3. Breach of any other conditions. May I just place it before your lordship? Page number 52. Yes, my lord. Condition number 3. In case the lessee or lessees, as the case may be, transferees or assignees commit breach of any of the conditions specified in clause 4 of part 3 and clauses 2, 3, 6, 10, 26 and part 7, then in any case, the state government shall give notice in writing to the lessee or lessees or its transferees or assignees, as the case may be, asking him, them, / it to remedy the breach within 30 days from the date of the notice. And if the breach is not remedied within such period, the state government may determine the lease. So this is my point. My lord, this is a condition precedent. Where in the show cause notice have I been told that this is the specific breach which you have committed and now you are bound to rectify it within a particular period of time, and if you fail to do so, then we will take penal actions as against you. Now, this is more like the principle of audi alteram partem. There has been a violation of principle of natural justice. My lord, a wrongdoer, allegedly, my lord, I'll say wrongdoer, must be put on notice that this is the mistake you have committed. Now you should resurrect yourself and you should carry on the business by doing this. But without issuing this notice, which is precursory to the issuance of the suspension order, now your lordship will also take up clause 5, my defense. Why I say, my lord, clause 5 is my defense? Failure on the part of the lessee or lessee to fulfill any terms and conditions of their lease shall not give the state government any claim such and such, insofar as the failure is considered by the state government to arise from a force majeure. So, my lord, I run a case of force majeure because, my lord, I cannot stop the flooding of the river beds. That is why I have admitted that, and that is why, my lord, force majeure is defined. Page 53, your lordship will find what falls within force majeure. Read rule 50. Yes, I'll come to that, my lord. I'll come to that. Read rule 50, sub rule 5. Yes, my lord. I'll come to that. I know your lordship has gone through the rules. No, my lord, I'll come to that. But kindly first, my lord, bears with me. What is there in the agreement? My lord, agreement is binding on both the parties. It's an agreement, my lord, which is there. It's not my agreement. It's a government's standardized agreement to which I had agreed to. So, my lord, the agreement itself postulates a situation by which any penal action ought to be taken against me.
which, my lord, clearly says that if I am in breach of any of the conditions, then I must be first put to notice and I must be said that no, this is the mistake you have committed. This is the correction you need to make within a period of 30 days. Now, even if I assume, my lord, that the show cause notice is that notice, kindly comes to the show cause notice. Kindly look at the date of the show cause notice. Page 76. 19th of June 2025. Even if I assume that this is that notice, then kindly sees what is written there within 7 days. So there is a clear violation of the agreement itself. Agreement says 30 days. Even if I assume that this is that show cause notice under that particular clause of the agreement. And then, my lord, your lordship will find that the action is taken prior to the elapsation of 30 days, that is on 2nd of June 2025. That is merely 14 days.
Very good. I am directing the authorities to take appropriate steps.
But in the meantime,
under section 55 within a specified time, and to take a partial reason order after giving you an opportunity of hearing, and in the event no order is passed, the suspension order will be withdrawn. I'm making a time bound order.
Yes, time bound. Because why I say so, my lord? Because I have already lost more than a month's time.
You have been served the show cause notice. You have given a reply. Now they have to take a decision. Now, keeping the decision pending, I believe it is your grievance that keeping the decision pending, we have been suspended for an indefinite period.
No, the decision has been taken. Page number P7. Page
No, that is the
70.
suspension notice.
Suspension.
Suspension has already.
Suspension is not the decision.
Yes, with the reply to
Mr.
the
Dhar,
notice.
My lord.
I propose to dispose of the instant writ petition
Yes.
to directing the ADM to initiate a proceeding and to conclude the proceeding under section 50 within a specified time
period
to pass a reasoned order after giving a chance of hearing.
Yes.
And till the day of passing of the reasoned order, the suspense order will remain force.
Yes.
And he is entitled to pass any order whichever you like in accordance with law. And in the event no reasoned order is passed within the stipulated period, the suspension order will be standing.
Absolutely. Fair enough.
The only issue here, what happens is that then also,
No more submission.
One more submission, my lord. Subject to correction, because my lord,
the time correction is needed. I am making a time bound order. Listen to my order.
Because my lord, I have already lost time. So
Actually, we'll lose.
If I succeed, my lord.
If I do cheating in my examination, definitely I will lose the examination.
Cheating or not, my lord, that has to be ascertained, my lord. That has to be ascertained.
If I
Page 78.
I am seeking for a rectification.
That I am doing. That exactly I am doing.
I was never given an opportunity of rectification.
Whether I have cheated whether I made cheating in the examination or not, that I am doing.
He is having a mind that, my lord, I have cheated. But, my lord,
who say I say I? I mean, I mean,
is the impression that, my lord, there is a foul play on the part of the petitioner.
He already admitted in his social.
Yes, I have admitted. I have admitted that I have accepted.
Have you heard that I have taken the name of the London Council?
No, Mr. Banerjee is absolutely wrong. My lord has said only about my lord.
I'll leave it to your lordship, my lord. Make it, my lord, short, very short time, so that, my lord, I can utilize the fruits of
by filing the instant writ petition.
I'm deeply on this.
Writ petition has paid for issuance of appropriate writ of the writs against the respondent authorities, more specifically against the respondent number 2 and 3, commanding them for revoking and or setting aside the order of suspension dated 2/7/2025. A copy of which has been annexed at page number 78 of the instant writ petition. I'm sorry, your good name, sir.
Pratip Mukherjee.
At the time of hearing, Mr. Mukherjee, at the very outset, draws attention of this court to Mr. to page number 76 of the instant date petition, being a copy of the show cause notice dated 19/6/2025, issued by the respondent number 3 authority. It is submitted that pursuant to such show cause notice, the writ petitioner has given a reply to the respondent number 3 authority on 24/6/2025, a copy of which has also been annexed at page number 77. It is submitted by Mr. Mukherjee that it is the grievance of the writ petitioner that without taking any decision over the reply dated 24/6/2025, the respondent number 3 authority.
My lord, more specifically, I'll say, my lord, without adhering to the clauses of the agreement, because the clauses.
I'll come to that. কি লিখলাম বলুন? The respondent number 3 authority most unilaterally
Number 16 and 17. My lord, kindly take it up 2 p.m. Great urgency is this, my lord. My
2 p.m. I take up the hearing.
my lord,
So the next-
Chandy Charan is appearing in the same similar matter. My lord also passed this order.
ওইগুলো নিয়ে যান
My
পুরো
lord,
adjourn.
my lord, in same matter, my lord.
2 p.m. I will take up the hearing matter. Sorry.
Great
the
urgency
next-
is this, my lord, in the
Everybody has urgency. What
Sir,
can
my
be
lord,
done?
kind of my house will be demolished.
Sir.
My lord, in the same
Sir,
matter, my lord also passed this order. Same matter, my lord also passed.
mention something about uh,
Wait, please, Your Lordship.
Tomorrow, what?
Well, the sustainability point of the matter is also a prime question. Sustainability of the matter. Because they have retired at that time.
Very good, I said, consider. Yes, sir, place your case.
That is what I'm saying. We have taken this point.
No, yesterday he has shown some papers which are distinct from the
That
others.
point is at variance, that only that much.
Place your case, sir.
Now,
এই ওইটা কি ওই জাজমেন্টটা আপলোড হয়েছে যেটা has it been uploaded?
possibly not, subject to correction not.
Will you kindly একটু তাহলে
Then
এদেরকে বলবো
probably
print
it
out
has been done.
It will be easier for me otherwise.
Yes, yes, of course.
What is the number, sir?
Number was 33771 W of 2014. Right? 1 W of 2014. In fact, it would be easier for us also too, because that's the context.
হয়নি কিছু কারেকশন ছিল আর কি ভেরি গুড এনিওয়ে প্লেস দি কেস
Now,
ফাইলটা কোথায় আমার কাছে আছে হ্যাঁ Yes, sir. Place your case.
Yes. Again, my lord, the facts are this. I joined as a physical PT instructor, physical training instructor on or about July 1981. Around 87, fourth pay commission.
You joined on?
July 22, 1981 as a PT instructor.
22/7/1981.
81. And I superannuated, just for my lord record.
As PT instructor.
As PT instructor.
Superannuated on?
September 30, 2010.
30/09.
2010.
2010. Yes.
Now, my lord, just to give the overview of the facts. 81 I joined, 87, around 87, fourth pay commission. I continue to remain with CPF.
Yes.
97, apropos the fifth pay commission recommendation, I say that I had given an option form for transfer from CPF to GPF.
Yes.
Again, my lord, as lordship has noted yesterday also, that I cannot show from record that in fact I had swapped it from as far as 97 is concerned.
In the year 1997.
That I cannot improve, my lord. Now, in 2010, this memorandum, the same memorandum
came to be published.
August 19, 2010 came to be published.
Yes.
That in this matter, lordship would find at page 28 of the writ petition. Lordship has found?
Page number 28. Yes.
28. I am on the second limb, as I pointed out the other yesterday. Now, next 2 pages concern my representation apropos this memorandum. Pages 29 and 30.
So practically in the last line of your memo,
Yes.
You have indicated
Yes,
that you have requested the authority for conversion.
Lordship.
Am I
Lordship,
correct?
Lordship, I bow down.
I
Now,
shall be grateful for the opportunity to change over to GPF
Lordship.
scheme to from my present status.
Lordship. So, my lord, if because it assumes significance, may I try to explain what it says in my own language, my lord? (1997) at the top right hand bottom, top right hand, July 25, 1997, Lordship has found that date?
Yes, sir. Yes, sir.
Yes. Now, according to me, this is the option form. Now, Lordship, at the top of this page, Lordship would find option for changeover form. Why I am saying this, why I am pointing it out, I am coming to that. So, this is an option form. That's the term. So, I say this is the option form which I had submitted in 97. Now, coming back to page 29, I say, look here, this is the option form I'm annexing again. And as fell from my lord rightly, I shall be grateful for the opportunity to change over to GPF scheme from my present status.
This letter you have submitted.
Lordship?
This letter you have submitted.
Yes, submitted.
What is the proof of submission?
It's 30. At the top, two envelopes from, one is Sri TK Guchai, the date it indicated at the left.
Sir, give me a second.
Yes, 24/8, that the signature also, apropos to the right of your lordship. Now, this I have.
Page number 30, you say, no?
Yes, 30. 29 is my application. 30 is that page of registrar.
Which one is yours?
At the top, at that very top. Two envelopes from.
You are Guchai.
Yes. Guchai. At the right of your lordship, lordship would find the signature also. 24/8. And deputy registrar.
Very good. So
Anyway.
this is the practically this is the
Yes.
Receiving register.
Yes. So what I want to submit is today, before I show the pleading, because there is some confusion in the pleading, that there are two things: 97 option form, 2008 application, annexing that option form. Now, apropos that, lordship would kindly first see that my paragraph 9, that is at paragraph 9 at page 8 of my writ petition. Paragraph 9, page 8 of my writ petition. Page 8.
Yes.
May I please paragraph 9? Thereafter, by a letter dated 24/8/2010, the petitioner duly submitted the option form, which was submitted by him in 1997. It was specifically contended in the said communication that the petitioner had duly submitted the option form in 1997, conveying his intention to be treated under the GPF scheme. In such communication, once again, the petitioner had expressed his intention to opt for GPF scheme. The factum of submission of the said letter dated so-and-so will be evident from the endorsement made in the registrar maintained by the authorities.
So in such communication, once again the petitioner expresses his intention to opt for GPF scheme. Is the last line of that memo?
Last, I bow down.
I understand.
Now, apropos that, because
What is their contention then?
Yes. Now, apropos that, lordship will straight away come to page 10.
Of their
Or rather, page 9 of the opposition. Page 9 of the opposition.
Page 9 of their opposition.
Yes. Page 9 of the opposition.
Paragraph number?
Paragraph 11.
Yes.
May I place the entire paragraph? It's not a. With reference to paragraph 7 of the petition stated that in terms of the decision of the Board of Governors, this 165th meeting held on so and so, the respondent institute issued a memo dated 19th August 2010. The said memo dated 19th August 2010 stipulated for examination on case-to-case basis and allowed only consideration for change from CPF to GPF scheme in respect to the employees having a proof of submission of option for change given earlier and such cases been not considered earlier due to administrative lapses. This I say is wrong as pointed out by my lord. Now, based on the above office memo, the petitioner applied for 24th August 2010 for conversion with a copy of the option form submitted on 6th August 1997, and after careful examination revealed that no such option was submitted in the establishment section is claimed. So they are saying that 24th August 2010, you are right, the petitioner had applied, but the option from the petitioner claims to have submitted in 1997, that was not there. We can find from the records. Now, what it means, I will come to, but the fact is, I had submitted in 2010. They admit this. So their only defense is that that memo only considered those cases where proof of submission option form back in 1990 was given, but could not be considered for administrative lapses. This is not such a case. That's it. Secondly, no answer. Now, Lordship would again, just to show their case, the page 10. 3 lines from top. As such, submission option as per aforesaid office order dated 25 July 1997 is not borne on the records of the respondent institute. It is stated that the case of the petitioner was examined in terms of the office memo dated so and so, but no administrative lapses were found with that respect, and thus the petitioner was beyond the scope of consideration. That's it. The second limb completely absent. No explanation even. Now, I could have understood there is some explanation. I have to deal with that. No explanation. This is one. The second part is, now Lordship would kindly take up paragraph 13 of my petition, which is at page 9 of my, sorry, my lord, I have to go back and forth a little bit. So, paragraph 13, page 9.
Give me a second, sir.
Lordship.
Paragraph 13.
1-3, page 9 of my read petition. I would explain, my lord, why it is of some significance. Page 9, paragraph 13. May I please? That subsequently, the Employees Association of the University addressed a representation dated so and so to the respondent number 4, pointing out the fact that although 67 employees have been confirmed with the benefit of switching over from CPF to GPF, but 5 employees, including the petitioner, who had retired during the period of 17/6/2010 to 31/12/2012, have not been considered for such benefit in terms of the decision taken by the Board of Governors in their 165th meeting. The corresponding document is, my lord, at page 32. Lordship has seen this previously in the other read petition.
Page number 32.
But 32.
The representation of
yes. Now, Lordship would kindly come to their opposition. How they deal with this? Page 11. May I, my lord, please? Page 11 of the opposition. Paragraph 14. 1-4.
Yes.
1-4. With reference to paragraph 13 of the petition, it is stated that the case of the petitioner was examined in terms of the office memo dated so and so, but no administrative lapses were found with that respect, save as aforesaid and save as whatever matters.
So all they are on all occasions they bank upon the clause 1, not clause 2.
Clause 2. And Lordship, if Lordship can kindly recall, yesterday said one is that it's arbitrary why that second limb, the clause 2 won't be considered. Also, it's discriminatory because employees retiring before a particular time has been excluded from the benefit. This case I have made out in paragraph 13 of my writ petition, read with that letter. This is the answer. No answer. This is the only answer.
But in the meantime, you have retired.
Yes. I ask myself.
Now, how this can, even if this court is
Yes.
satisfied,
Yes.
how this can be done?
Yes. Now, two things. First, this refusal of benefit.
Have you understand my question?
Yes.
That for the sake of argument,
Yes.
if I accept your contention,
Lordship.
that the IIT authority ought to have considered your application
Lordship.
as per the second limb of the circular,
Lordship.
and then how the relief can be granted to you.
Yes.
That is
Now,
the question.
Lordship. Now, I'm grateful Lordship is pointing this out. I will, my Lord, show. Lordship would kindly take up yes. Should kindly take up their opposition. Lordship would kindly take up yes, page 15 of their opposition. There is also another answer to this, but I will come to that later. Page 15, Lordship has taken up. Opposition. 15.
Yes.
আপনাদের opposition. My learned friend cannot seemingly find this.
You make your services, sir.
Lordship has found this one. Yes. Now this is the 87 memorandum which came in apropos, my lord, the fourth pay commission. I have, my lord, referred to this. Now, mechanism is, my lord, there is a mechanism. Now, Lordship would kindly take up paragraph 3.3. This is not, my lord, unheard of. The CPF beneficiaries who were in service on so and so but have since retired and whose case retirement benefits have also been paid under the CPF scheme will have an option to have their retirement benefits calculated under the pension scheme provided they refund to the government contribution to the contributory provident fund and the interest thereon drawn by them at the time of settlement of the CPF account. And, my lord, I have taken specific
The CPF benefits were in service and but have retired and retired and in whose case retirement benefits have also been paid. This will option to have their retirement benefit come. Yes.
So, my lord, I say this. There are 2, 3, my lord, fold.
There is a mechanism.
2, 3 linked to this answer. First is, if I have been first, I have taken specific instruction. If Lordship so desires, we can put it in an affidavit also. There is no issue. That whatever direction would be passed by my lord, and of course, has to be accounted for whatever benefit you have got. We have obtained the benefit of CPF at the time of retirement. We will have to, my lord, account for that. This is one. Second is, on principle of law, if I have been, this is a beneficial measure that was proposed time to time from CPF to GPF, and why it was proposed, my lord, I have the authorities why it was proposed. There are several Supreme Court judgments which deal with this. CPF to GPF, this kind of retirement benefit measures, why it was proposed. Now, if that be the case, my lord, I, for no fault of my own, my lord, cannot be excluded from this retirement benefit. And Lordship would kindly appreciate, I had applied for this benefit at the time, at the extent time, and before my retirement. Now, only because the implementation of this benefit has been deferred, of this memorandum. That, my lord, cannot probably, my lord, subject to correction, prejudice me. Third, as I pointed out, the model is already there. What has to be done? This page 15.
Where from will get the date of implementation?
That, my lord, that letter, that employees association letter, there we have, my lord, said this, and they have not denied. My learned friend can deny that. My learned friend can deny that, but from affidavit, lordship would not find that. Lordship would not find
No,
that.
the memo contains
Memo
no
did
date.
not, nothing. Memo did not do anything. In fact, my lord, from the, I was, my lord, of course.
The memo contains no date.
Nothing.
They say that they will consider.
They will consider.
You are agreed for your non-consideration
Lordship.
on account of the presence of the second leave.
Lordship.
And your contention is that since there is a mechanism here, if I accept your contention, I can adopt this I can adopt this mechanism while passing a favorable order in favor of the writ petition.
Lordship.
This
May I, my lord, add one caveat to this? Lordship, in fact, sitting in this jurisdiction, need not even pass that I subject to my lord lordship's, of course, pleasure. Need not even pass a direction saying, going in minutiae as to what would be, how it has to be done. Lordship can simply say, my lord, again, my lord, subject to correction, that whatever benefits we have got, that has to be accounted for. And the rest can be, my lord, worked out. That is, my lord, not my lord lordship determination. Lordship cannot be bothered.
See, so far the CPF is concerned,
Lordship.
employee gives the contribution and the government gives the contribution.
Lordship.
And in GPF there is no such scheme.
Lordship.
GPF only contribution from the
Lordship.
Only contribution from the employee.
Lordship.
And in case of GPS scheme, you are entitled to pension.
Lordship. Lordship. That is
your main motto, to get pension.
That is the real reason. Lordship would kindly appreciate at the time this.
Any other point you want to highlight?
Yes.
If necessary, don't unnecessarily waste the time.
The thing is, just to, my lord, cover my bases, just to cover all my bases, because I am also, my lord, this is an institution against me, and this litigation might not stop there. May I, my lord, I would not burden my lord with placing each and every judgment. May I only just place, just refer to certain judgments, and I would indicate on what point I am showing. Just paragraph numbers, citation of judgment, and what point I am showing.
So,
may I only do that? I don't want to burden.
If those are relevant.
Yes, I think these are relevant, but now, as far as, in fact, my lord, would it be lordship's pleasure to hear out the third matter also, and then?
Very good. I can.
Because the facts I cannot improve. These are the facts.
I'll take up the matter. This
very good.
This matter is identical with this.
That part of fact lordship has to see, because that point is in my lord's mind as to what is the manner of receipt. Only that. Otherwise, it's same. Otherwise, it's.
Not sure.
Here, lordship would find that the concerned memo is.
No, is there any register here?
No, here, no.
If there is no,
yes, lordship would.
Proof of service of your representation dated 24th August 2020.
Signature at the bottom at page 31.
And what is the reply to that?
And the seal. And the seal is also there at the top of that page. Yes. Now.
No, what is the reply to that?
Yes. Now, lordship would kindly come to. Yes. Yes. Paragraph 13. Paragraph 13, page 11 of the opposition. Lordship has found. It is further stated that based on the above office memo, the petitioner applied on 24th August 2010 for conversion. Paragraph 13, 1-3, page 11 of the opposition.
Opposition?
Opposition.
Oh.
Oh, lordship wants me to place that because that pleading. Yes. Lordship would then, in my read petition, Lordship would kindly come to page 10, page 8, paragraph 10 in my read petition.
Para 10.
Para 10 in my read petition, page 8. Now, Lordship would.
Just a minute, sir.
Yes. Yes. Now, Lordship would kindly consider
By letter dated 24 to petitioner duly submitted for which was submitted by him and special content despite submission. Copy of the communication is added P6. What is P6, sir?
Yes. Lordship.
P6.
Yes. P6 is, my lord, at page 31. Yes. Page 31.
It bears this
seal and seal. At the top is the seal. And then the signature. At the bottom.
what they have replied to?
Yes. Page 11 of the opposition. Same as the previous matter. Paragraph 10, paragraph 13, 1-3. Page 11, paragraph 13.
বললাম বাবু এই রিফিউজিং অপোজিশনটা কোথায়?
In opposition, my lord, this is
Yes, I got it. I got it.
page 11.
13, no? So they've admitted the receipt.
Yes. But again, they say 97 is not available, and that's the only reason for refusal.
So these two are identical.
Yes.
What they said?
Yes. My lord, 6-7 lines from the bottom of that page 11. It is further stated that based on the above office memo.
No, that I've gone through.
Yes. Yes.
Apart from there are no difference. Now, so the judgments.
Yes. Now, before judgment, one more fact I must bring my lordship. Now, this memorandum that we are placing before your lordship is only, my lord, the office order. It's the office order based upon which we are doing. Now, this office order, lordship has seen, refers to a meeting, the entire thing.
Board of Governors.
Board of Governors. Now, in our petition, in our reply, everywhere we have said that, of course, we do not have access to that. What do you mean by administrative lapses? What cases? What has happened? Nothing. We have called upon them. Because this entire thing about how it was received, this is also kind of administrative lapse. This entire thing is there. Now they
are not banking upon that. You are on.
I am banking on this. I am banking.
You are on the part 2.
Part 2.
You say that you come under part 2. Whatever you do, you take to decision according to that one.
I only want to point out that they have not disclosed. This is all. So, lordship would draw my lordship friends. Anyway. They সব আছে দেখ আমার কপি আছে লর্ডশিপ কপি জাস্ট বলছি জাস্ট প্যারাগ্রাফ নাম্বার the first judgment I want to rely on the point is that pensioners constitute a homogeneous group based merely on the cutoff date of the retirement, there cannot be any discrimination. This is the first judgment I want to rely on.
No, sir, why it is relevant? Have they disclosed that based on such and such?
No, they have not. But
Then
that
why
is
are they giving that?
another point of attack. So I do not want Lordship.
Why? Have they disclosed that because of this cutoff date you have been eliminated?
They have
Not
not.
so.
They are completely silent.
Please take your seat.
Lordship.
Don't make it unnecessarily clumsy.
No, I am not making plans.
No, I'm not. I'm telling you, Mr. Dasgupta. Yes, Mr. Mahujumdar.
First of all, I am coming to
Number 2.
annexure R2
of
epidemic in opposition.
First matter, Lordship. Today's first matter.
Annexure R2.
What was the position at that point of time?
Page number, sir. Page number.
Page number 17.
Yes.
My lord. May I read it, my lord?
Yes. Please, sir.
The understanding is to say that competent authority has been pleased to approve implementation of the central government decisions in regard to the above mentioned matters in the institution in terms of the Government of India, Ministry of Pension, Ministry Pension, and the pensioners. Welfare Office Memo number 4187 PIC-1 dated 1/5/87, copy enclosed. In this connection, it may be noted that no option has been envisaged for a change over GP pension gratuity secondary to CPF gratuity scheme. The option in terms of the aforesaid office memo is to be exercised by 31st of October 1987 in the form of enclosed ballot. Understand that. It is no option in receiving the above date from the employment who are in the role of the institute. They will be deemed to have over GPP pension gratuity scheme. Option once exercised shall be final.
But it is GPF to CPF.
GPF?
It is GPF to CPF.
Yes.
But their case is CPF to GPF.
It was GPF to CPF they came.
Huh?
They came to CPF from GPF. They came to GPF.
Remained in. This memo was issued on 14th September 1987, Lordship. Contents have already been, Lordship, addressed. Lordship, kindly last line, Lordship, my landed signature already addressed. Option 1 exercise shall be final, Lordship. In terms of this notification, Lordship, in the year of 1987, Lordship, kindly look into next page, Lordship, page 18, Lordship. Lordship, This particular writ petition, Lordship, the Indian Institute of Technology, Kharagpur, this is a form of option. I, Tapan Kumar Guchait, employed as physical training instructor in the Department of TS Gymkhana, do hereby opt to continue under Contributory Provident Fund scheme in terms of the office order dated 14th September 1987. Lordship, kindly see the signature. Thereafter, on the kindly see rubber stamp. Thereafter, in the Lordship, in the bottom portion, kindly see entries made in the S book for attestation and memo is put up for signature.
Just a minute.
And in the bottom portion, Lordship, after the signature portion, Lordship, type copy, Lordship, opted for retention of existing terms.
No option.
GPF
Just a minute, sir.
as
Just a minute. Just a minute.
Lord.
Just a minute. No option has been envisaged for a changeover from GPF to CPF from gratuity scheme. So in terms of yes.
Now, Lordship, in terms of that earlier notification, which was circulated in the year of 1987, Lordship, in that notification, it is clearly mentioned the option 1 exercised, it is final, Lordship. Now, Lordship, in terms of that notification, Lordship, he has exercised this option in his own handwritten in the form of the IIT, which was prescribed in the concerned memo, Lordship. Now, Lordship, in the bottom portion of the page 18,
So by page number 18,
Lordship,
see, he expresses the intention to remain in CPF scheme.
Lordship, because Lordship, he still, when he was appointed, Lordship, in the year of 1981, he was still in the CPF, Lordship. Now, when the option was floated in the year of 1987, in respect to this memorandum, Lordship, he has also taken steps with regard to that form of option as CPF, Contributory Provident Fund. And that is
No,
final, Lordship.
will you please come to page number 17 once.
Lordship.
Page number 17,
Lordship.
first paragraph, last sentence.
Lordship.
In this connection.
In this connection, it may please be noted that no option has been emphasized for a
Envisage.
Lordship, for a change over from GPF come CPF come gratuity scheme to CPF come gratuity scheme, Lordship. And thereafter,
So no option has been envisaged for a change.
Lordship.
And what does it mean?
And therefore, the option in terms of the aforesaid office memo is to be exercised by 31st October in the same year, Lordship, to the undersigned. Therefore, Lord, can you see, if no option is received by the above date from the employees who are on the roll of the institute, they will be deemed to have come over GPF come pension gratuity scheme. Those person, if no option is received, but this particular petitioner employee, Lordship, he has taken the option as CPF. And Lordship, kindly see the last line, option once exercised shall be final. Kindly see the last paragraph, Lordship, once more. Lordship. If those persons who have not taken option, they will be treated as GPF. But if those persons who have taken the option under CPF, Lordship, that is final, Lordship. Once option was exercised, shall be final, Lordship. An initial appointment, Lordship, was governed by the CPF. And subsequently, when this memo and when the memo was issued in the year of 1987, Lordship, which I am referring to you, Lordships, it is final. He has taken the specific option. It cannot be changed in subsequent way, Lordship, in terms of this memo in the third paragraph. But my learned friend never shows this document. This is the institute case, Lordship. Lordship, kindly see page 18, bottom portion, Lordship.
Give me a second. So this memo says changeover from CPF to GPF. It says the option is to be exercised by 31st of that month, 31st October 1987. It further said if no option is received, then they will be under GPF. But once option is exercised, that shall be final. Now you say, by exercising his option to remain in CPF, that has become final. So therefore, he cannot take the benefit of that. So which one is earlier?
1987, Lordship.
And what is the board resolution?
Board resolution 2010, Lordship. Page 18, Lordship. In the bottom portion, it is clearly indicated, Lordship, opted for retention of existing terms of statute under section 18. I am guided by this memorandum, Lordship. And it is his own handwritten, Lordship. And it is duly countersigned. All the departmental correspondence is there, Lordship.
That's all.
And Lordship, regarding Lordship, and on the basis of that, Lordship, we have issued the notice of superannuation, Lordship.
Please come.
And Lordship, later of 1997, another indicated.
I understand your context.
Lordship.
May my lord give a reply to this?
No, not required. লাগবে না রাখুন এখানে পড়ে নিচ্ছি একটু আমাকে দিন না
If lordship desires, I can.
No, not required, sir. No reply is required.
Employees were in CPF. That's why the conversion came in.
Very good, sir.
And
listen to my order. Take down. দুটো ম্যাটার একসাথে, otherwise very interesting.
No, 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 no. Lordship has. Facts are facts. Lordship.
ওইটা ফেরত যে এই যেটা এলো ওটা আবার চেম্বারে চলে যাবে।
Respondent KMD Lordship led by Mr. Satyajit Kalu. আমার আর পড়ার বেশি কিছু নেই। ঠিক আছে, লিখে দিতে।
এফিডেভিট করেছো? এফিডেভিটটা কালকে বলেছি তো, আমি কালকে টাইম নিয়েছি, আমি এফিডেভিট করে দেবো। My lord, only one, my lord, I want to cite one decision in. No, my lord. No, my lord. 330, there is a resolution. I have never violated any resolution of our association. No, my lord. My lord, I have submitted that the record of rights, the no, I am not repeating anything. My lord, I am saying that the Prafullo Kumari Devi did not, in the resolution there is no averment. What is the source of his recording? How she became the owner? However, in the record of rights, the name of there, in the who died in the year 1950. There is no such averment. What is the source? And Bharat record of right disclosure, Bharat Sarkarer পক্ষে collector. There is no disclosure of in source that it is the property of her husband or it flows from the any settlement from the government of Union of India. There is no such disclosure. And my lord, to that effect, my lord, I want to cite one decision. My lord, that is 19.
Sorry. Tomorrow we'll just file an affidavit.
Yes.
For the submission of document.
Yes.
If there be any extra.
No. I am concluding my submission here and now.
No, I'm not that. Tomorrow, yesterday I directed to file the copy of that notice by way of supplementary.
Yes.
You have to file that affidavit only without making any assertion.
My lord. Without any assertion, without.
I will give a oral reply because I've got the document.
That is why I restricted it.
But I will show
Otherwise, you will file against an exception, etc. I will not
I'm
allow.
thankful to Mr. Mahato. The document which he has brought, he strengthens my argument. I will.
Yes.
That you will.
But perhaps there is some misconception with you, and that is why you are submitting that.
Be that as it may.
My lord, my lord, it is, my lord, reported in 1988, 4 SCC, page 534, only one paragraph. 3-4. This is famous judgment of Bharat Singh case, my lord knows.
No.
Paragraph 13.
রেসপন্ডেন্ট স্টেট লেখো, কাজ আমার কাছে করলে পরিষ্কারভাবে করবে। একাধিক রেসপন্ডেন্ট আছে না, কি করে বুঝবো?
ও জানে ও জানে এয়ার 1988 2000 না না, এটা হচ্ছে না বলে দিচ্ছি তোমাকে 1988 4 SCC page 534 paragraph 13. My lord, I am placing. As has been already noticed, my lord, this is relating to the land acquisition matter. Although the point as to profiteering by the state was pleaded in the writ petitions before the High Court as an abstract point of law, there was no reference to any material in support thereof, nor was the point argued at the hearing of the writ petitions. Before us also, no particulars and no facts have been given in the special leave petitions or in the writ petitions or in any affidavit, but the point has been sought to be substantiated at the time of hearing by referring of certain facts stated in the application by the HIDC. In our opinion, this is the opinion of the Supreme Court, when a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he, the writ petitioner, must plead and prove such fact by evidence which must appear in the writ petition, and if he, the respondent, from the counter affidavit, if the facts are not pleaded or the evidence in support of such facts is not annexed to the writ petition or to the counter affidavit, as the case may be, the court will not entertain the point. In this context, it will not be out of place to point out that in this regard, that there is a distinction between a pleading of the Code of Civil Procedure and a writ petition or a counter affidavit. While in a pleading, that is, a plaint or written statement, the facts and not evidence are required to be pleaded. In a writ petition or in the counter affidavit, not only the facts, but also the evidence in proof of such facts have to be pleaded and annexed to it. So the point has been raised before us by the appellants is not entertainable, but in spite of that, we have entertained it to show that it is devoid of any merit. My argument is to the point is that the Prafullo Kumari Datta, he has not, there is no statement that from which source she became the owners of this land. And the relating to the malord 3-1 malord, I have got the notification, so that is also ought to have been pleaded and prayed for in the writ petition. Otherwise, writ petition is not maintainable. But I have already got the 3-1 malord. It will be malord I found. And malord, I am concluding this, that the Supriya Datta or the proponent respondent, there is not a scrap of paper that they were in possession or they are the owners of the land and they have become the owners of the land. There is no such pleading, nothing. It is totally devoid of merit. So, my lord, I am concluding this submission. So, what have the points I have taken that, and I will submit that, my lord, only this 3-1 by way of
to supplemental affidavit. Mr. Talukdar will argue. Mr. Datta, where is he?
Today, my lord, he said that it is going to 3:30, so he was at the time of my lord was dictating that.
Ashun, Mr.
Make any further submission, only the
Only filing.
yes.
Tomorrow at 3 p.m.
But I was only beseeching my friend, my lord, if he can supply, because Mr. Dotto will argue without judgment, I don't think so. My lord, if he can supply the citations now,
No, before,
they can
before we
make submission, how can?
No, how can I? It's an unjust prayer.
my lord. Beneficial prayer, my lord.
The prayer, I cannot say right now the prayer made in the writ petition is unjust. That I cannot say. But the prayer made by Mr. Chatterjee right now is unjust.
Yes. Well, it's a beneficial prayer.
It would be in our respective submission what has fallen from your lordship, the fast.
Yes, we will accept all, we will stand on that.
No, that I will say.
In fact, his submission, my lord, we have to answer on several points. On several
ঠিক আছে,
aspects.
আজকে এত সাহায্য করে।
Sir, one thing I must.
my lord,
Mr. Datta will argue. 2 minutes left.
No, Mr. Mahato, I think, has finished.
Finished.
Tumboli section.
Tomorrow by you.
হ্যাঁ,
3 p.m.
সেকশন 3 ওটা শুধুমাত্র আমি দিয়ে দেবো।
Mr. Tarakdar, what I am on, that whatever arguments that have been advanced from the members of the bar, and whatever been the result that enriches the court, that I must admit.
The same here also, my lord. We also learn every day when we lose weight.
Mr. Chatterjee, learning is a continuous process. And I'm really thankful to all the members of the bar.
That we live to learn.
We will live to learn.
So whatever argument I have heard, whatever block point I have heard, it enriches me like anything. Thank you.
আমি শুধু একটা জাজমেন্ট দিলাম।